Her daughter spent 40 minutes on the phone trying to cancel a subscription for her 92-year-old mother. 40 minutes. And when she finally hung up, exhausted, relieved, the charge showed up again the next month. Because it was never actually canceled. Here's what made that possible. SiriusXM could cancel any subscription with a single click. One click. But they designed the process to take 40 minutes on purpose, because the longer you stay on that call, the more likely you are to give up. They built a system designed to wear you down. And in most states, that system is perfectly legal. California just changed that. And what they found inside these companies is something every American with a subscription needs to hear. Think about how many subscriptions you're paying for right now. Not the ones you use every day, the ones you signed up for, forgot about, and never got around to canceling. The average American is wasting $204 a year on subscriptions they don't use. That's not a guess. That's a survey of over 2,000 people conducted in 2025. $204 a year on charges that just keep coming. And nearly 2 out of 3 Americans have been charged for a free trial they forgot to cancel. You signed up for something free. You meant to cancel before it converted. You didn't. And by the time you noticed, you'd already paid for 2 months, 3 months, sometimes more. This isn't about being irresponsible. This is about a system that is specifically engineered to make sure you forget. These companies know the number. They've calculated exactly what percentage of people who sign up for a free trial will forget to cancel. It's built into their business model. It's built into their revenue projections. Your forgetting is their profit. And the question is, what can you actually do about it? The answer depends on where you live. And most Americans have a lot less protection than they think. Let's go back to that SiriusXM case. Because what the New York Attorney General found inside that company should change how you think about every subscription you've ever tried to cancel. When investigators got access to SiriusXM's internal training materials, they found a script, a literal script that agents were required to follow whenever a customer called to cancel. It had 6 parts. Step 1, ask why they want to cancel. Step 2, pitch an offer to stay. Step 3, if they say no, pitch a different offer. Step 4, if they say no again, ask more questions. Step 5, pitch again. Step 6, if they still want to cancel, start over. Agents were explicitly trained not to take no for an answer. That's not an interpretation. That's what the documents said. And SiriusXM's own internal data showed the results. The average cancellation by phone took 11.5 minutes. Online chat took 30 minutes. 30 minutes to cancel something you signed up for in 30 seconds. Meanwhile, inside the company, any agent could cancel a subscription with a single click. The technology to make it instant existed. They just chose not to use it for customers. The New York Supreme Court ruled in November 2024 that SiriusXM violated federal law with this process. Not because cancellation was impossible, but because it was deliberately, intentionally designed to be hard enough that people would give up. Think about how many people gave up. Think about how many people are still paying for something right now because they tried once, hit a wall, and told themselves they'd deal with it later. That's not an accident. That was the plan. And SiriusXM is not an exception. They just got caught. What if you did everything right? What if you went through every screen, clicked every button, got the confirmation email, and they charged you anyway? That's not a hypothetical. That's what the Federal Trade Commission said happened to thousands of Chegg subscribers. Chegg is a study platform used by millions of college students, tutoring, textbook rentals, homework help, and a subscription model that, according to the FTC, was designed around one core strategy: make canceling complicated enough that people stop trying. The FTC's case laid out exactly how it worked. When a student tried to cancel, they weren't taken to a cancellation page. They were taken to a series of pages, confusing pages, pages that looked like cancellation but weren't, pages designed to create enough friction that the student would eventually close the tab and give up. And for the ones who made it all the way through, some of them received a cancellation confirmation and were still charged the following month. Not because of a technical glitch, because the cancellation flow itself was built with gaps that allowed charges to continue even after the process appeared complete. In September 2025, the FTC reached a $7.5 million settlement with Chegg. The company was ordered to simplify its cancellation process and refund affected customers. $7.5 million. For a company targeting college students, people already stretched thin between tuition, rent, and groceries, who were being quietly drained month after month by a service they thought they'd already canceled. Now here's the question that changes everything. Chegg was held accountable in federal court. SiriusXM was held accountable in New York, but both of those cases required years of investigation, attorneys general, federal agencies, and lawsuits that most people never even heard about. What happens when there's no investigation? What happens when it's just you and a charge on your statement and no one is coming to help? The answer to that question is written in your state's law, and depending on where you live, that answer might be nothing. You just saw how these companies operate. You saw the script they hand to agents. You saw students charged after confirming cancellation. And you're about to find out what one state discovered inside these companies that was bad enough to completely rewrite the law. If that matters to you, and if you want to know the exact steps you can take today to protect yourself, subscribe to Law Drop right now and hit the bell. This is exactly the kind of thing we cover every single day. And if this video is already worth it, hit the like button. It takes 1 second and it helps more people find this. Stay with me, because what comes next is the part the companies don't want you to see. California has had a law regulating automatic renewals since 2010. Most states don't have anything like it. But California looked at what was happening: the scripts, the cancellation mazes, the charges after confirmed cancellations, and decided that wasn't good enough either. So in September 2024, Governor Gavin Newsom signed Assembly Bill 2863. It went into effect July 1st, 2025, and it changed the rules in ways that no other state had done before. Here's what the law now requires for any subscription sold to a California consumer. First, express affirmative consent. Not a pre-checked box buried at the bottom of a sign-up page. Not a terms and conditions link that nobody reads. The company has to get your explicit, documented agreement to the automatic renewal terms before they charge you anything. And they have to keep proof of that consent for at least 3 years. Second, free trials are now covered. Before this law, a company could offer you a free month and then quietly roll you into a paid subscription with minimal disclosure. Not anymore. In California, converting a free trial into a paid subscription now requires the same explicit consent as any other automatic renewal. Third, canceling has to be as easy as signing up. If you signed up online in 2 clicks, you can cancel online in 2 clicks. The company cannot route you through a phone call, a chat agent, or a retention gauntlet just because you want to leave. Fourth, price increases require advance notice. If your subscription price is going up, the company has to tell you 7 to 30 days before it happens. Not after, before. And fifth, every subscriber gets an annual reminder. Once a year, the company has to send you a notice that tells you what you're paying, how often you're being charged, and exactly how to cancel. Now think about how different that is from how most subscriptions work right now outside of California. But the law is only as strong as the people enforcing it. And California didn't stop at legislation. They built a task force. The California Automatic Renewal Task Force, the CART, is a coalition of district attorneys from Los Angeles, Santa Clara, Santa Barbara, San Diego, and Santa Cruz. Their only job is to investigate companies that violate the auto renewal law and hold them accountable. In April 2024, they went after Thrive Market, an online grocery subscription. The result? more than $1.5 million in penalties and consumer restitution. That's not a federal agency. That's a coalition of local prosecutors who decided this mattered enough to build a dedicated enforcement unit around it. No other state has built anything like it, at least not yet. Here's the part that most people never find out until it's too late. Your right to cancel a subscription, your right to get your money back when a company charges you after you've already canceled, is not a national right. It's not guaranteed by the Constitution. It's not protected by a single clear federal law. It depends almost entirely on what state you live in. California has the strongest auto renewal law in the country. New York updated its law in November 2025. Now companies have to get your affirmative consent before raising prices or let you cancel for a prorated refund. Minnesota passed its first auto renewal law in January 2025 and went further than California on one specific point. Companies in Minnesota cannot even make you a discount offer during cancellation unless you specifically ask for one. Colorado, Arkansas, Massachusetts, Utah, Virginia, all have meaningful protections on the books. That's a growing list, but it's still a short list. Because right now, if you live in Texas, Florida, Alabama, Mississippi, Louisiana, Georgia, Indiana, Ohio, or dozens of other states, your only protection is a federal law called ROSCA. Check your state laws, because this landscape is changing. The Restore Online Shoppers Confidence Act passed in 2010, and the terms clearly, simple, and easy, the words the law uses to describe what companies must do, have never been precisely defined by any court or federal agency, which means companies have spent 15 years finding out exactly how unclear, complicated, and difficult they can make cancellation before a federal regulator decides to do something about it. Think about what that means in practice. A person in California signs up for the same streaming service as a person in Texas. Same company, same subscription, same price. The person in California can cancel in 2 clicks. The company has to remind them once a year that they're being charged. If the price goes up, they get 30 days notice. If they're charged after canceling, they have a clear legal path to get their money back. The person in Texas, they get whatever that company decides to give them, which, as you've seen in the last 10 minutes, might be a 6-part retention script, a series of confusing cancellation screens, and a charge that shows up the month after they thought they were done. Same company, same subscription, different state, different rights. And most people have no idea which side of that line they're on. In October 2024, the Federal Trade Commission did something it hadn't done in 50 years. It rewrote the national rule on automatic renewals. The new rule was called the negative option rule, and it would have done for every American what California's law does for Californians. It would have required every subscription company in the country to get your explicit consent before charging you. It would have required cancellation to be as easy as sign up. It would have required clear disclosure before any free trial converted to a paid subscription. For everyone, not just people in the right states. Everyone. The rule was set to go into full effect on July 14th, 2025. On July 8th, 2025, 6 days before the deadline, a federal appeals court threw it out entirely. Not because the rule was wrong, not because protecting consumers from subscription traps was a bad idea. The court vacated the rule on a procedural technicality. The FTC had failed to conduct a required economic impact analysis during the rulemaking process. A paperwork problem, a missed step in the process. And just like that, the rule was gone. There is a bill in Congress called the Unsubscribe Act. It has support from both parties. It would require companies to get your approval before charging you after a free trial ends, and would make cancellation as simple as sign-up, nationally. As of early 2026, it has been introduced in both chambers. It has not passed either one. And the FTC, after the court threw out its rule, filed paperwork in January 2026 to start the rulemaking process over from scratch, following the correct steps this time. But a process like this can take years, 3 years, sometimes more. So right now, today, in most of this country, there is no federal rule. There is no national standard. There is no click-to-cancel law that applies to everyone. What exists instead is a patchwork. A growing patchwork, yes, but still a patchwork. And if your state isn't on that list yet, you are operating without a net. Let me show you exactly how this works as a business. When a company builds a subscription product, they run projections, revenue models. And inside those models, there is always a number, a percentage, the percentage of subscribers who will forget they're being charged. That number has a name in the industry. It's called passive retention. And it is not an accident, it is a strategy. The gym industry understood this before anyone else. You sign up in January, you go 3 times, you stop going. But you keep paying because canceling feels like admitting defeat, because the process is annoying, because you keep telling yourself you'll start again next month. Equinox built an entire cancellation policy around this psychology. The New York Attorney General's investigation found that the company buried its subscription terms in fine print, never obtained proper consent for automatic renewals, and offered no easy way to cancel online. When the settlement came, $600,000 in May 2025, it covered subscribers who had been affected going back to 2021. 4 years. 4 years of people paying for memberships they couldn't figure out how to end. Adore Me ran a different version of the same playbook. You'd visit their site looking for a deal. You'd find a discount, a real one, a good one. You'd take it. And buried inside that transaction was an enrollment in a monthly subscription program that would charge your card every month going forward. Not a free trial, not a clearly disclosed membership, a discount that came with a subscription you didn't know you'd agreed to. The Maryland Attorney General shut it down in May 2025. Here's what connects every case in this video: SiriusXM, Chegg, Equinox, Adore Me. None of them are outliers. None of them represent a company that went rogue. These are mainstream companies with mainstream products used by tens of millions of Americans that deliberately engineered the experience of leaving to be as difficult, confusing, or invisible as possible, because they ran the numbers. And the numbers told them that every obstacle between a customer and a cancellation is worth money. Every extra screen, every hold time, every confusing confirmation page, every missing cancel button, worth money. Your frustration is a revenue line item. So here's what you can actually do about it. And before I go through this, everything I'm about to share is for informational purposes only. This is not legal advice, and laws vary by state. If you have a specific situation, talk to a licensed attorney. What I can give you is the framework these companies don't want you to know exists. Because here's the thing. The companies have studied your behavior for years. They know when people give up. They know what makes someone close the tab, and they've built their systems around that. But there are specific steps that change the equation, and they work regardless of what state you live in. Step 1. Always cancel in writing first. Before you pick up the phone or open a chat, send an email to the company's customer service address. Subject line: cancellation request, your account name or email. Body: I am requesting immediate cancellation of my subscription effective today. Please confirm this cancellation in writing. 1 sentence. Send it. Screenshot it. Save that email. That email is now a time-stamped document. If they charge you next month, that document is evidence that you requested cancellation on a specific date. That matters in every state, and in some states it's the difference between winning and losing a dispute. Step 2. If you're charged after canceling, dispute it with your card. Credit card chargebacks exist for exactly this situation. Call your bank or card issuer and tell them you were charged after canceling a subscription. Most major cards will initiate a dispute and temporarily reverse the charge while they investigate. You will need documentation, which is why Step 1 matters. This works even in states with no auto-renewal law. A chargeback is not a legal claim against the company. It's a dispute through your financial institution. The company then has to prove the charge was valid. Step 3. When you cancel by phone, say these specific words. I am canceling my subscription effective immediately. Please confirm my cancellation number and the date my billing will stop. Then write down the name of the agent, the time of the call, and the confirmation number they give you. If they don't give you one, ask again. If they refuse, that refusal is information you'll want documented. Step 4. Report it. If you're in a state with an auto renewal law, California, New York, Minnesota, Colorado, Massachusetts, and others, file a complaint with your state attorney general's office. These offices track patterns. The Equinox case, the Thrive Market case, those started with complaints from people exactly like you. If you're in a state without a specific law, you can still file a complaint with the FTC at reportfraud.ftc.gov. The FTC can't help every individual consumer, but the cases they build, including the Chegg case, start with complaint data. Your complaint might not get your money back tomorrow, but it adds to a record that gets cases opened. Now here's the part that changes how you think about all of this. These companies have spent years and millions of dollars studying exactly how to make you give up. They've calculated the optimal number of steps before a customer abandons the cancellation. They've designed the friction intentionally. But the moment you send that cancellation email, document the call, and know how to dispute a charge, you've stepped outside the system they designed for you. They built the maze for people who don't know these steps. You know them now. Send this to someone who's been charged for something they already canceled. You know someone. 2 minutes of your time might get their money back. Like this video, subscribe to Law Drop, and hit the bell so you don't miss what's coming next. And drop cancel in the comments if this hit home. Because next, your employer is scanning your face and your fingerprints every single day at work. And in most states, they can keep that biometric data forever, share it with whoever they want, and never tell you what they're doing with it. That video is next.